Merci, Maître Lana. Maître Saccucci, please.
Mr. President, members of the Court, before addressing the main arguments of the Slovenian government with respect to the Chamber's findings, allow me to briefly comment on the overall strategy pursued by the respondent in the present case. Since this application was first lodged with the Court in 2006, the government has repeatedly and consistently denied any responsibility for the erasure and its consequences. Today, the government will try to persuade this Court that a genuine change in the course of action has taken place in Slovenia since the delivery of the Chamber's judgment. A new law has been enacted with a view to settle the situation of the many erased still awaiting a permanent residence permit, and some of the applicants have in fact been issued such permits since July 2010. In light of these developments, the government will argue that the matter under consideration has been resolved by an appropriate systemic solution, and that the applicants can no longer be considered as victims for the purpose of Article 34. In other words, the government will seek to close the match with a tied score on the assumption that the facts complained of have ceased to exist. I should then immediately stress that the dispute at the core of the present procedure is far from being resolved, and that the applicants, all of them, are still victims of the violations found by the Chamber, irrespective of whether they have been eventually issued with a permanent residence permit. Indeed, it is enough reading through the government's written submissions to realize that the initial good propositions are no more than an empty gesture aimed at sugarcoating the facts in the hope of a more lenient assessment by this Court. The government still firmly denies its responsibility for the violation of the applicants' rights under the Convention. It has still the bravery to claim that it is not true that the applicants had to endure a period of insecurity and legal uncertainty. And the bravado goes even further when it asserts that they had at their disposal effective remedies to challenge the persistent failure to regulate their legal status. Having this context in mind, Mr. President, in my following submissions, I would respectfully argue that, firstly, the nature of the violation of Article 8 and Article 13 complained of by the applicants is such that it cannot be remedied simply by fulfilling ex post facto the obligations ensuing from the Convention. Secondly, the fact that some of the applicants were issued before or after the Chamber's judgment a permanent residence permit cannot be regarded as an adequate and sufficient redress for the violation of their Convention rights. Thirdly, the new law implemented in Slovenia for regulating the status of the erased cannot be regarded as a general measure capable of removing the systemic defects and the long-term effects of the violation of the Convention rights for the purpose of Article 46. As my colleague already pointed out, the Chamber's judgment has found a breach of the applicant's Article 8 rights as a result of the prolonged refusal of the Slovenian authorities to regulate the applicant's situation comprehensively. The Chamber has also found a breach of the right to an effective remedy, holding that the applicants did not have at their disposal any remedy which could be regarded as effective under Article 13. Therefore, the very essence of the violation of the Convention rights lies in the present case on the existence of an administrative practice incompatible with the Slovenian Constitution and with the Convention, a practice of non-compliance with the Constitutional Court's decisions that lasted for a substantial period of time. Even assuming that following the adoption of the 2010 law, the overall attitude of the Slovenian government towards the erased had changed, an assumption which is, to say the least, questionable, this would only serve to put an end to the continuing interference with the applicant's rights on Article 8. But certainly, it would not extinguish the government's responsibility for having breached continuously those rights over the past 20 years. The continuing nature of the violation is of crucial importance in this case. According to the case law of this court, a state remains accountable for a continuing violation of the Convention rights, even if it ultimately acted as required in order to put an end to the situation of non-compliance. For instance, an interference with property rights originating from the failure of the authorities to act as prescribed by law, such as in relation to non-execution of an enforceable judgment, remains a violation of Article 1, Protocol 1, even if the judgment has been executed pending the court's decisions in the complaint. With specific regard to the right to private and family life, in Mehemi versus France No. 2, the court found that even if the applicant was issued with temporary residence permit following the first court's judgment, he could still claim to be a victim of a violation of Article 8 in relation to the period, only 5 months in that case, when he was prevented from enjoying his family life in France. In this latter respect, the court has made a clear distinction between the cases involving deportation of non-nationals on one hand, and the cases concerning the failure to regulate the applicant's legal status for a long period of time on the other hand. In the first category of cases, such as in Sisoyeva and Kaftailova versus Latvia of 2007, the court has held that an applicant can no longer claim to be a victim of a deportation measure if the measure in question is not enforceable, or if he has been issued a residence permit. While in the second category of cases, such as in Aristimuno Mendizabal versus France of 2006, and in Mengesha Kimfe and Agra versus Switzerland of 2010, the court has clearly stated that the issuing of a residence permit is not, in itself, sufficient to redress the long period of insecurity and uncertainty experienced by the applicants. While the present case does not concern the compatibility of an expulsion order with the Article 8 rights, such as in the Latvian cases, but rather the continuing interference with those rights resulting from the failure of the domestic authorities to regulate the applicant's legal status. Having said that, Mr. President, with your permission, I will now briefly underline two key aspects of the case that are closely related to the continuing nature of the violation to which I just referred. The first aspect concerns the question of whether the applicants, including those who have so far been issued with retroactive permanent residence permit, can still claim to be victims under Article 34. It is our respectful proposition that all the applicants still retain the victim status and that regulating their legal status after many years of unlawful interference cannot be regarded as an adequate and sufficient remedy for their complaints on Article 8 and 13. Notably, in light of the court's case law concerning the notion of an effective remedy, we believe that the granting of retroactive permanent residence in the course of the present proceedings can only be seen as a measure for putting an end to the interference under Article 8, but certainly not as a measure capable of redressing the serious consequences occasioned by the erasure and by the prolonged failure to comply with the Constitutional Court's judgments. As we extensively illustrated in our memorial, an effective remedy for the purpose of losing the victim status requires that the national authorities have acknowledged, either expressly or in substance, and then afforded redress for the breach of the Convention. Now, in the present case, it is clear that the Slovenian authorities have not acknowledged the violation of the rights complained of before this court, nor they aimed to do so. Moreover, it is undisputed that they did not afford the applicants any appropriate form of relief for 20 years of unregulated status, nor they intend to do so. It follows that the issuing of a residence permit does not cancel the long period of legal limbo in which the applicants lived since 1992. This conclusion is particularly reinforced by the consideration that the applicant's situation was caused by an unconstitutional action, the erasure, compounded by an unconstitutional inaction, the failure to comply with the Constitutional Court's judgments. Thus, unlike in the Latvian cases, the deprivation of permanent residence status has been carried out in flagrant breach of the domestic law. In this context, it should be emphasized that the retroactivity of residence permit has no practical meaning. Indeed, the retroactive residence permit will not give the applicants any specific entitlement for the past, but it will simply settle their legal status for the future. The so-called supplementary decision is just a piece of paper. A piece of paper. With this piece of paper, the applicants cannot claim any right, any compensation, any restitution. Thus, retroactivity is purely declaratory. Serious moral and material damages suffered by the applicants, namely due to their prolonged deprivation of status, require further remedial action, namely the adoption of pecuniary and non-pecuniary individual measures of reparation. In its concluding observations of 2010, the Committee on Elimination of Racial Discrimination stressed that the situation of the erased was still not resolved after the enactment of the new law, and that the Slovenian government should, and I quote, grant full reparation, including restitution, satisfaction, compensation, rehabilitation, and guarantees of non-repetition. Apart from pecuniary compensation, other measures are required in order to redress the violations suffered by the erased. For instance, in its 2011 recent visit report, the Commissioner for Human Rights emphasized that no measure for reunification of families have been provided in the new law. The concluding observations issued just a few days ago by the Committee Against Torture also urged the government to facilitate the full integration of the erased persons, including those who belong to Roma communities. As a consequence, it is our respectful opinion that the Grand Chamber should overturn the Chamber's findings according to which the issuing of a retroactive residence permit constitutes an adequate and sufficient remedy. As we set out in our memorial, there can be no distinction depending on whether the applicants were issued permanent residence before or after the delivery of the Chamber's judgment. Any other conclusions in this respect would lead to unfair or unreasonable consequences, which would be at odds with the idea of the Convention protecting rights that are concrete and effective. In other words, should the court hold that the issuing of permanent residence deprive the applicants of their victim status, the government would be able to circumvent the obligation to comprehensively address the situation of the erased. This is particularly unacceptable in cases where the violation stems from a systemic problem affecting many other persons whose legal status remain unsettled. Should we then just wait for another complaint to be lodged with this court by those erased who did not yet get their status back? The second aspect I would like to focus on concerns the question of whether the new law can be regarded as a general measure capable of comprehensively address the situation of the erased, and to remove, once and for all, the systemic violation of the Convention rights. Slovenian government argues that by implementing the new law, they complied with their obligation under Article 46. We strongly oppose to such a proposition for the following main reasons. Firstly, it is our view that the question of whether the new legislation in force constitutes an appropriate general measure should be reserved entirely to the competence of the Committee of Ministers in the exercise of its functions under Article 46(2). Secondly, the 2010 legislation is prima facie insufficient for the purpose of remedying the violations found by the Chamber, and the latest figures available on its implementation fully supports such a conclusion. As of June 2011, only 127 applications for permanent residence permit have been lodged by erased persons on the basis of the new law, out of over 13,000 eligible persons. Out of these 127, only 30 applications were accepted, while 60 have been dismissed, and the others are still pending. The high rate of rejected applications, nearly 50%, shows that the new legislation does not resolve the situation of the erased. In our memorial, we have set out the main flaws of the 2010 law, which will most likely prevent many erased and their families from regulating the legal status in Slovenia. And the same shortcomings have been underlined by the Commissioner for Human Rights in its recent report, and also in the concluding observations I mentioned before of the UN committees. Namely, the 2010 law still requires the person concerned to lodge an application, to pay the administrative fee, to translate documents submitted as evidence, to attend a hearing in Slovenia, all of which is time-consuming and rather costly, especially for those who live outside Slovenia. But most of all, the law still places upon the erased the burden of proving that they meet the conditions set out therein, including that they have been de facto living in Slovenia since the erasure onwards, or alternatively, that they fall within one of the permitted exceptions. Now, there are persons who are not able to satisfy the required standards of proof. There are persons, such as, for instance, Dabetic and Ljubenka Ristanovic, who certainly do not fall within any of the permitted exceptions. In any case, and I'm going to conclude, it is unacceptable that after many years of unlawful interference with Article 8 rights, the applicants are still today required to fulfill a number of formal conditions to get their status back. It is our view that the law should instead provide one single condition for the issuing of permanent residence permit, that is, the fact of having been erased. Moreover, as stressed by the Commissioner for Human Rights, the new legislation does not provide any specific mechanism for affording the erased a fair compensation for the consequences of the many years of unregulated status. In the present case, Mr. President, it is imperative to erase the erasure, which means not only regulating the status of the persons affected, but also setting up a comprehensive legal framework for affording them adequate relief for the past. And in this latter respect, I will reserve the right to develop some further observation when responding to the government's pleadings on the applicant's claim for just satisfaction on Article 41. Thank you, Mr. President.
Thank you, Mr. Saccucci. I now call for the government, Mr. Bembic. Mr. Bembic, please.